Keckering.
Thank you very much, Mr. Deputy Speaker. I'm very grateful to the Leader of the House for creating an early opportunity to debate the report of the Committee on Privileges, which we published last week, and for tabling a motion in the terms which the committee had requested. She was good enough to inform me that she would not be able to be present in the chamber herself this afternoon to move the motion, and I also thank the honourable member for Blackpool North and Cleveland for introducing the motion and for his support for the report of the committee. The case has proved rather protracted for reasons that I will come on to, but in essentials it's been a very simple matter, and I'll try to keep my remarks as brief as possible. As the honourable member outlined, Mr Cummings failed to obey first an order of the DCMS committee and then of the House itself to attend an oral evidence hearing. When this was referred to the Privileges Committee as an alleged contempt by the House, we agreed a resolution on process which is appended to our report. This was based on a resolution agreed by our predecessor committee some years ago when considering the case of News International witnesses who were alleged to have committed a contempt by misleading a select committee. And we have adhered strictly to the procedure set out in that resolution, even although this has had the effect of lengthening our inquiry. Mr Deputy Speaker, we invited Mr Cummings to give oral evidence, but despite our giving him ample opportunity to agree a date with us, it proved impossible to do so. In an email to us, and again in his blog last week, Mr Cummings has made various misstatements about this, and I don't wish to detain the House unduly, but I do want to put on the public record a rebuttal of one or two of his assertions. In his blog, Mr Cummings says, talking of the date of a projected evidence session before the Committee on Privileges as agreed in December, and I quote, "We tentatively agreed the 31st of January, but they cancelled the hearing in January and declined to reschedule it." The report sets out what actually happened. At the start of December, we offered Mr Cummings a selection of dates for a hearing in January. In response, Mr Cummings told us that he would probably come on the 31st of January, the latest of the dates we had offered, but that he would confirm to us before Christmas. He didn't. I wrote to him on the 10th of January seeking confirmation. I received no reply to that communication. The clerk to the committee emailed him on the 23rd of January, seeking a response. He replied on the 28th of January, again I quote, "Hello, I've just seen this, I will reply this afternoon." There was no further reply. On the 29th of January, with 2 days to go till the date of the proposed evidence session, and having had no confirmation that he would attend it, the committee met and decided that we had no alternative but to cancel the session and bring our inquiry to as rapid a conclusion as possible. In his blog, Mr Cummings says that, and again I quote, my last letter to the committee of the 26th of February is below, I got no answer. Mr Deputy Speaker, that is quite untrue. On the 28th of February, 2 days after his email, I wrote to him, responding in detail to the comments in his email. I received no reply to this. All these letters, emails and responses are published on the committee's website. At an earlier stage, and similar to the experience of the DCMS committee, Mr Cummings had insisted that all the members of Parliament taking part in the Privileges hearing should take an oath. I replied, pointing out that this would not be possible. We were willing to administer the oath to him at his own request, but the oath could only be administered to witnesses, just as in law courts, the judge or barristers do not take the oath. In his blog, Mr Cummings describes this argument as laughable. He also says that the committee, and I quote, replied that no, they didn't want to promise to tell the truth, and sadly they weren't able to make such a promise, but would I come anyway? These comments were completely fabricated. I won't carry on, Mr Deputy Speaker. Anyone who wants to can read our full report and the various letters and emails published within it and make up their own minds as to whether it was the Committee of Privileges or Mr Cummings who was behaving unreasonably. Notwithstanding the responses from Mr Cummings, I want to assure the House that the committee has done our very best to approach this case scrupulously. Our report assesses whether Mr Cummings' conduct amounts to contempt of Parliament. It might seem obvious that a refusal to obey an order of the House or of its committees is a contempt of Parliament. However, in certain exceptional circumstances, it is conceivable that a prospective witness might be justified in declining to give evidence if they had genuine grounds to believe they'd be treated unfairly, or that giving evidence might significantly prejudice future court proceedings against them. Our report considers the arguments advanced by Mr Cummings to see if there were extenuating circumstances that might have justified his conduct, and in particular, as has been raised by honourable members opposite, the risk of legal proceedings against him. It concludes that Mr Cummings had been offered by the DCMS committee a series of alternative dates for a hearing, and that he had not supplied any evidence that he was at significant risk of criminal prosecution, or which suggested any significant flaw in the DCMS committee's inquiry or in their handling of witnesses. Legal inquiries into whether or not he was or others might have been at risk of future criminal proceedings were assessed in the light of assurances that we received from regulators, which led us to understand that he himself was not facing criminal proceedings. We agree with the DCMS committee that Mr Cummings' evidence would have been relevant to their inquiry, and we heard from the chair of the committee a few moments ago more detail about why that would have been the case. And we agree that his refusal to attend was a significant interference with that committee's work. We conclude that he committed a contempt by his refusal to obey first the committee's order and then the House's order. We recommend that he be admonished by resolution of the House to be communicated to him by the Clerk of the House. We do not recommend the old practice of summoning him to the bar, which we believe would merely give him an opportunity to grandstand. The motion before the House, in conjunction with the report which it approves, constitutes the admonishment. If agreed to, no further action by the House will be sought in this matter. Finally, we comment, and this too has been raised a number of times this afternoon, that the case of Mr Cummings has raised further questions as to the enforceability of the House's powers and those of its committees to secure evidence. It is for that reason and others that the Privileges Committee will now return to its wider inquiry into these matters, referred to as in the previous Parliament, and we plan to announce shortly a series of oral evidence sessions. We hope to coordinate our inquiry with the Liaison Committee's current inquiry into Select Committee effectiveness. I'd be very happy to give way to the Right Honourable Member.
Is the Honourable Lady in the committee going to pursue comparisons to see what might be working more effectively in other democratic institutions?
I'm very grateful for that suggestion, Mr Deputy Speaker. I think it's an excellent one. May I also urge Honourable and Right Honourable Members in this House to submit their own evidence to the committee, and we will be publishing details shortly of how to make those submissions. Mr Deputy Speaker, I think it's been apparent to all of us for some time that the current situation is unsatisfactory. I acknowledge that admonishment is a fairly feeble sanction against an individual who does not appear to feel a sense of shame at his own behaviour. The historic punishments used by the House, fining and imprisonment, have not been used for many years, and although they have not been abolished, it's highly unlikely that any attempt to use them now would survive a legal challenge. None of the alternative options, which may be summed up as doing nothing, attempting to assert the House's rights through resolutions or standing order changes, or legislating to confer powers on the House, is, I acknowledge, without objection, which is why this problem is still with us. If the answer had been easy, something would have been done a long time previously. Notwithstanding this, the committee wishes, as I say, to canvass options vigorously, including, as the Right Honourable Gentleman has suggested, looking at how other legislatures around the world have dealt with this issue. We will focus not only on ways of strengthening sanctions, but also ensuring, as we have striven to do in this inquiry, that the House is fair and scrupulous in the way that it treats witnesses. We intend to report to the House with proposals as soon as possible. Mr. Speaker, may I conclude by placing on record my thanks to my colleagues on the Privileges Committee for their assistance in bringing this report forward to the House, to the leader for proposing the motion this afternoon, and her colleague for introducing the debate today. I too urge the House to support the motion tabled in the name of the leader.